I want to thank everyone for attending this timely seminar today. We really brought together a fantastic panel of attorneys from our practice group to help you navigate the complex areas of constitutional protections as they relate to the rules and regulations restricting signs and flags. With me today, I have Tana Bucca. She's a shareholder in our Becker Community Association group. Tana's been practicing for nearly 20 years and has clients throughout the state of New Jersey. David Dockery is a senior attorney with our firm's Community Association group. Dave represents condominium homeowners and co-ops, both in New Jersey and New York. He's been featured recently in articles focused in the open meeting requirements, holiday decorations, and board transparency. His practice is centered primarily around general counsel, transactional, and collection matters for our clients. Ellen Goodman is also a senior attorney with our firm's practice group. Ellen spent her career representing community associations throughout New Jersey. She serves as general counsel for her clients, as well as handles all collection and transition matters. We really think this webinar will assist you in dealing with the issues that arise when residents place signs and flags on association property, especially at this time when we're experiencing a very hotly contested national election where differing ideas become very contentious. If you can move to the next slide, please. Are you on the number 3? Thank you. I'm sure all of you have heard the questions about signs and flags. Can they be prohibited? What if the governing documents prohibit signs? What types of restrictions can be imposed? What happens if a sign restriction is violated? How can we enforce restrictions? Are American flags considered political signs? These are all very important questions, but to understand their answers, we must first do a quick review of the Constitution, relevant case law in New Jersey, in order for you to understand how these answers can be reached. Next slide. As we know, the proliferation of community associations has brought to the forefront rules and regulations that govern communities. These rules usually affect the use of common property and the use of homes. Some of these rules relate to what could be considered restrictions upon free speech, which is typically guaranteed by the federal and state constitutions. These rules might affect the person's right to post signs and flags on common areas of an association and on their own homes. As you can imagine, when owners don't understand the rules or they feel like their rights are being taken from them, owners may feel compelled to challenge the association's rules. These challenges can then result in costly litigation, which no one wants to be involved with. New Jersey courts have addressed the rights of associations to adopt rules and regulations, specifically affecting freedom of speech of its members, as well as their members' rights to post signs and flags on their own property. But before we look at some of those cases, let's take a review of the US and New Jersey Constitution and some of the case law. Next slide. Let me go through a few of these slides quickly, but anyone on this program will have a link after the program is over for you to review them in more detail at your leisure. This slide shows the exact language of the First Amendment. And you can see that the First Amendment to the US Constitution states in part that no law can be made or enforced that would abridge freedom of speech. Next slide. Since the First Amendment only applied to federal action, the 14th Amendment was adopted, making the First Amendment protections enforceable against state action. And again, this slide provides you with the exact language. Next slide. New Jersey also adopted a First Amendment type protection in its own state constitution, which grants to individuals the right of free speech and assembly in a broader manner than provided for in the First and 14th Amendment of the US Constitution. And again, this slide provides you with the language. Next slide. You may be asking, how do these constitutional rights apply to a community association setting? Although the US Constitution does not directly apply to a community's enforcement, since there's no state action, New Jersey's Constitution does provide individual protections, even where the federal Constitution would not, which can then be enforced against the private party. There are two seminal cases in New Jersey, State versus Schmid and New Jersey Coalition Against War in the Middle East versus JMB Realty. These cases address the constitutional right of individual free speech on private property and establish the standards or tests that a court uses to determine if private property rules violate the state's constitution. Next slide. The Schmid case involved the enforcement of a Princeton University rule protecting the distribution of political literature on campus by a non-student without the university's permission. The person was arrested, convicted for trespassing while distributing the political material on campus without their permission. But after the conviction, he appealed, claiming that his arrest was unconstitutional because the distribution of the material was protected by both the First Amendment of the US Constitution and Article 1 of the New Jersey Constitution. Princeton University argued that as a private institution, it was not subject to the federal or state constitutions regarding freedom of speech. The court rejected the university's position regarding the state constitution, and in reviewing the case, the court crafted a test for use to determine if freedom of speech was unreasonably abridged on private property. This is known as the Schmid test, which requires the court to use a three-pronged analysis to review. Was the nature, purposes, and primary use of the private property generally its normal use? The extent and nature of the public's invitation to use that property, and the purpose of the expressional activity undertaken upon such property in relation to both the private and public use. When the court applied this test to Princeton's policy, the court found that the distribution of political literature was consistent with both the private and public use of the campus. The university invited the public to use its facilities, and that Princeton's regulations contained no standard for governing the exercise of free speech. In other words, they had failed to memorialize their regulation on political speech. There were no rules, so it was arbitrary as to why they would grant it. As a result, the court concluded that Princeton violated the defendant's constitutional rights to free speech and assembly and reversed the conviction. Later, a court reviewed the Schmid test in the coalition case. In this case, and if you could do the next slide, please. Thank you. This case addressed the distribution of political material, but in a shopping mall setting. Although the court applied the Schmid test, it also relied on a general balancing of the expressional rights and private property interest. The court found that after balancing between the protections to be accorded the rights of a private property owner against the free speech right of an individual for leafleting on the private property, the individual's expressional right to leaflet prevailed. The court also recognized that the shopping center had broad powers to adopt reasonable rules concerning the time, place, and manner for leafletting, and concluded that the rights of free speech are protected by the New Jersey Constitution from state action and interference by private property owners. The Schmid and coalition cases led to the New Jersey Supreme Court ruling in what many of us may have already been familiar with, the Committee for a Better Twin Rivers and the Mazda Brook Homeowners Association case versus Kahn. These cases looked at the applicability of the New Jersey Constitution to a community association's enforcement of rules and regulations related to signs and other restrictions. Next slide, please. In Twin Rivers, a group of residents believed their rights were being violated by Twin Rivers rules that had restricted a resident's ability to erect signs, use a community room, and publish in the association's newspaper. Unlike the coalition case, Twin Rivers actually did have a rule. It said that a resident could post one sign in any window of their home and a second sign in a flower bed no further than 3 feet from their home. The association stated that the purpose of that rule was to avoid the clutter of signs and to preserve the aesthetic value of the common areas. The residents brought an action arguing that the association had abridged their right to free speech. And then in this case, the Supreme Court of New Jersey reviewed the broad nature of New Jersey's free speech rights, and they applied the Schmid and coalition analysis to the facts and determined that the Twin Rivers was a private residential community, that it had not invited the public to use its property, which differs from the Schmid case and the coalition case, and that the members of Twin Rivers had voluntarily decided to enter a contractual relationship by purchasing their homes to abide by the contested restriction that they were complaining about. As a result, the court found that the members' expressive activity had not been unreasonably restricted, and that the minor restriction on the plaintiff's activities were not unreasonable and not unconstitutional. It further stated that the covenants and restrictions contained in the governing documents are essential to the fundamental nature of community association living, and that although the association had restricted the private property of its owners by applying some rules to what they could do on their own property, the restrictions did not violate the property owner's constitutional rights, as long as they were reasonable as to time, place, and manner. As a result, the Twin Rivers Court found that the association's restrictions did not violate the residents' constitutional right because they had the ability to exercise their freedom of speech, but just simply had to comply with the reasonable time, place, and manner restriction imposed by Twin Rivers. Next slide. In the Mazda-Brook Commons Association versus Khan, Mr. Khan had posted political signs on doors and windows of his home in a community association because he was running for office in the municipality. A few days after posting the sign, Mr. Khan received a letter from the board stating that the political sign violated their association governing documents, which banned all residential signs except for sale signs. In applying the Schmid three-prong analysis, the court found, like in Twin Rivers, that the first two prongs supported the association's reasonable restrictions on free speech. However, when they reviewed the third prong, dealing with the actual activity being restricted, the court found that the association restricted political speech, and that such speech lies at the core of our constitutional free speech protections. The court balanced those restrictions on free speech against the interference of the association property and found that the near complete ban on signs cannot be considered a minor restriction and a window sign in support of a candidate is a relatively minor interference with the property rights of the property owner. The court noted that the association had the power to adopt reasonable time, place, and manner restrictions to serve the community's interest, but instead chose to impose a total ban with the exception of for sale signs, and therefore the rule violated the state's constitution. Now that we've gone over the important constitutional analysis and the case law, we get really to the substance of the discussion and probably why most of you have come to join us today in this seminar. Therefore, to answer some of those important questions, I'm now going to turn this part of the program over to Ellen Goodman. Thank you all.
Sorry about that. Thank you, Arnold, very much. I appreciate that. If we could just move on to the next slide, please. So the hot topics right now, obviously, as Arnold said, it's the very highly contested election, as well as just the additional political movements that are going on, brings up the question of what is considered a political sign. As you can see, we've put together just some examples. The basics, the Trump and Penn sign and the Biden and Harris sign on the top, right, and left, those are obvious. Those are political signs. The one that would not be a political sign would be the home of the Norwin graduate on the bottom. That is obviously somebody who's celebrating their child. Now, the question is the ones that would lie in the middle. Are they political or are they not political, such as the other three signs? And while we cannot provide you with a hard line of yes, this is political, yes, this is not political, we can provide you with the standard that you and your board should be looking at to discuss and to determine what should be allowed in each of your community associations. And what should also be considered political and fallen under the certain guidelines, which my colleague David will also be discussing later on in the program. So if we can move on to the next slide. So most associations these days have rules that say, no commercial signs, meaning no signs such as a for sale sign or the advertising the roofer who's doing the roof, or advertising the contractor who's redoing a unit's bathroom. Those are the easy, no, we don't want these types of signs in the association. The question becomes, as Arnold was discussing the standard, that we cannot limit all political signs. So as Arnold had said, in Moderator, this case, the Moderator versus Con case, it was determined that you cannot do a complete ban on residential signs, on political signs and residentials, because in that situation, it hampered the most basic right of Mr. Khan to speak about the political office and his own candidacy for office. So in that case, you have to come up with some reasonable rules of time, place, and manner. And that's important. But the next case, this Dublier versus Linwood case, they adopted a standard that says that you need to, that the association, when evaluating whether or not the sign should be allowed or not, you need to look at the purpose of the expressional activity in relation to the property's use. And you need to balance the unit owner's right to express their opinions with the private property rights of the association as a full. So for instance, to use the graduation sign, that's a pretty, basic sign that we all do see around May and June, around lots of neighborhoods. And this sign, most people would say, well, our association says no sign. Should we or should we not ban it? And that's where the board and managers should be looking at this standard of Dublier that says, well, what's the expressional activity that this homeowner is looking to express versus their right? Well, for instance, this is a private home and somebody is looking to express their right in their residential community to celebrate their child graduating from middle school or high school or college. They're graduating to celebrate that, wonderful life event of their child. So that's where the board and manager and in consultation with your attorney would want to look and see what type of, what message is that sign stating. So then also the political movement signs that we're dealing with now, this is where you would also want to apply that same test. So you would want to look at some of those other signs. I'm sorry, Laura, can we go back one slide, please? Sorry, I know we're not supposed to go back and forth. We would want to look at some of the other signs, like the Thank You Healthcare Hero sign, or the sign that's that talks about, we celebrate everything. And you would want to look at that and say, what is this message trying to get across? And that would be the important test and standard for managers and your boards to look at when determining if a sign is considered commercial or political, and then also whether or not the sign should have certain restrictions. If we can move on to the next slide, and then the slide after that, please. Okay, so then the next question is, once it's determined, well, we're going to allow everybody to display, whichever sign, where can these signs be displayed? As we said in Moderator, it came up with the kind of rule of thumb that the associations should look at time, place, and manner. Well, one place that we never want these signs to be on would be on a common element. So for instance, if this is a condominium or a townhome, we would not want a sign to be on the siding. That would be damaging property. In addition, the association can limit if somebody in a condominium decided to put a flagpole, harness it to a tree trunk. That is a common element. No unit owner should be damaging a common element. Or if it's a high rise, maybe a sign shouldn't be up on the bulletin board. Things like that are pretty basic of saying, no, you don't want to do that. The question becomes, what about if somebody wanted to put it outside in their flower bed? Even if it's a townhome community and that's considered a common element, would that be considered damaging? If somebody put in, a little sign right outside in front in the mulch. Nothing large. That's where we get into the gray area. Definitely, as a rule of thumb, you would want to prohibit, any banner that would fall over a balcony, or any sign, obviously, that would be attached to the outside of a unit. And you would also want to prohibit any sign that is going to block a vendor from doing their work, including the most basic of trash cans and delivering mail. So if somebody's going to put a sign right in front of their mailbox and say in a townhome, and that's a common element, the sign might be small enough, but the postal worker might not be able to deliver mail, or they might not be able to take the trash. And then, of course, obstructing traffic. We would never want a sign to be put that would cause an accident. I know these things seem very basic, but it's important to understand that these are the rights that the association has to limit the place of these signs. Examples of where it would probably be considered reasonable would be if somebody put a sign in their window, whether it be the condo or the townhome, put a sign in their window. Or if it's a homeowners association and this is their single family home, and they are, say, responsible for every part of their lot, somebody put a sign in their lawn. As long as it doesn't obstruct traffic, that should be considered acceptable. Same thing with exteriors of front doors. So basically, you would not want to get in the way of a vendor, and you would also want to allow all of your unit owners to have their freedom to express how they feel, whether it be for who they're going to vote for in November or the current political movement, or even possibly that their child has been graduating from school and they're celebrating that life event. So with that said, I'm going to turn it over to my colleague, David Dockery, who's going to discuss more rules that the association may want to put in place for this issue.
Hi, good afternoon, everyone. Thank you, Arnold, and thank you, Ellen, for laying some wonderful groundwork for what I'm about to discuss with you this afternoon. So the big question, particularly starting several months ago even, was from clients and from managers asking this very question: what if your governing documents say no signs allowed? Many associations have these kind of restrictions. Some of these were put in declarations and master deeds and bylaws and rules and regulations before the Supreme Court ruled on some of these cases. So, we are dealing with this, and some of your associations out there may have these rules in place with not being fully familiar with the current law out there. So going back to the Moderator case, indeed, they had a restriction except a for sale sign, which is also very common. So if there's anything that you want to take away from today's webinar, is that if you have a complete restriction against signs or limited to, let's say, just a for sale sign, that is not enforceable, subject to the exceptions for political signs, as we'll discuss. So Laura, if you could go to the next slide, please. So while a complete restriction against signs may not be constitutional or permitted, let's not forget the Twin Rivers case, which provides guidance, and Arnold summarized that case earlier. So in the Twin Rivers case, again, an owner under the rules at Twin Rivers was allowed to put a sign both in the window and no more than 3 feet from the exterior of the building. Ideally, a rule like that would probably be due to landscaping concerns, et cetera, and to avoid clutter within the association. And the primary holding of that, which is still our rule of thumb today, is a community association can reasonably limit the time, manner, and place of political expression. But how that plays out practically, that is the difficult issue. And that is something that is definitely fact sensitive. Ellen summarized some of the instances where boards will have to make decisions about what they would and what they can and cannot allow. So if we can go to the next slide. I wanted to put on the screen so all of you can see the exact language that we might see from a real set of governing documents. And that's actually from the Moderator case. And so if you see here, there was a statement set forth in the public offering statement, not necessarily enforceable just simply because it's a public offering statement. But indeed, the declaration says no signs shall be erected or installed in or upon the building, the common facilities, or any part thereof without the written prior consent of the board. And again, the rules and regulations also reiterated that rule. So what's interesting about the Mossbrook case that I find is that this gentleman, Mr. Khan, who was running for the town council, it was his own home. He was arguing, this is my house. I'm allowed political free expression for my candidacy. He only put a sign in his window so you could see it through the glass. And then he also put it on the door. It sounds like it was maybe a glass storm door or something that he put a sign. He was fined, et cetera, et cetera. Interestingly, in this case, there was quite a bit of litigation about his rose vines, which was another interesting aspect of the case. But the Mossbrook court focused on Twin Rivers. And the association argued that Twin Rivers allowed the association to limit time, manner, and place. Therefore, they could prohibit Mr. Khan's signs. And if you go to the next slide, the court in Mossbrook made a distinction. And they basically said that in the Mossbrook scenario, the association was foreclosing out an entire means of political expression. So by saying that, they said that while you can restrict time, manner, and place, you cannot completely ban, the holding was particularly political signs in the Mossbrook case, but you can't foreclose out a completely whole method of political expression. In fact, I believe in Mossbrook, if Mr. Khan wanted to distribute leaflets, things like that, that might have been acceptable. And in fact, the lineage of cases Arnold talked about earlier discussed the right, briefly touched on that. That's a topic outside of our webinar today. But it was too much. Twin Rivers only provided minor restrictions. Mossbrook went too far. So if we can go on to the next slide. And when we're talking about time, manner, and place, I think that the easier analysis is the manner and place. For example, my colleague Ellen discussed the size of signs, placements of signs, location of signs, perhaps the number of signs. Twin Rivers, for example, allowed 2 signs, and the court thought that was reasonable. But when we are analyzing time for an election cycle, let's say for our general national election that's going on right now, that's sort of much easier to say, you know, if an association wanted to say 30 days before the general election and within 1 or 2 weeks after, you are allowed to put, let's say, for example, 1 or 2 signs up for your candidate. It can be no bigger than 2 feet by 2 feet. Like Twin Rivers, you can put 1 in the window, or you could put 1 in the flower bed, as long as the landscapers aren't going to, you know, run it over with a lawnmower, et cetera, that's okay. But what we're seeing recently with newer political movements, Ellen showed some great examples of some signs, is while again the manner and place might be a little bit more easy to regulate, what are we looking at as far as, you know, political movements? How long can the signs be put up? And I don't think we have any clear answers. Again, I look to the Mossbrook case, and you know, you have to ask yourself: are we foreclosing out a means of political expression if we were to say, for example, a certain time limit to an ongoing political movement? So again, these are really fact-sensitive matters that boards have to discuss with their council and determine what kind of restrictions, if any, they want to put in place. So if you can go to the next slide, please. So my favorite judge here, Judge Judy, how do we adopt policies that may be enforceable? Well, I find that boards become very upset when they have a restriction that completely bans all signs. And Now here comes the court along saying, no, you must allow political expression. In fact, the homeowner, I'm sorry, the board president in Mazda testified, well, the reason why we don't allow signs is because we don't have to make these kind of decisions. So I think that's an interesting and very practical and real concern for boards and managers out there. But we do have the guidance of Twin Rivers and Mazda as what we can do. And if the association feels that they do need to enforce some sort of or dictate some sort of rule as to signs for very, very good reasons, aesthetics, landscapers, the mailman, people tripping over things, you know, part of living in a community association is to have uniform appearance, et cetera, et cetera. So what we recommend is that you do have a policy, and it's a written policy. And I'm always, and I'll say it again, that these policies have to be enacted in an open meeting of the board, and they have to be reasonable under the criteria. So it's suggested that you work with counsel to put those policies in place. I think you also need to be careful to look at your governing documents to ensure that indeed that your policy, your written policy, is grounded in your governing documents. Do you have the right to fine? Do you even have a sign restriction in the governing documents to begin with? So again, counsel will help, you know, guide you through all of these considerations. And without a policy, the court will really come down, I think, on associations that arbitrarily enforce restrictions without this policy in place. And even the policies that are in place are going to be under a considerable amount of scrutiny with these cases, these court cases we've presented before you. And so I always caution my clients that, you know, there's sort of a rebuttable presumption that a sign at the end of the day is political, you know, absent some other considerations that my colleague Ellen spoke about. So with all of that, I will turn this over to my colleague, Tana Bucca, to talk to you about flags.
Thanks so much, David. Thank you, everyone, for joining us. I wanted to talk a little bit about flags, and specifically our flag of the United States of America. First, I want to talk about what is the proper way to display the flag. Our federal government has actually adopted what is called the United States Flag Code. That was adopted in 1942, and it's been amended from time to time. It is advisory. There are advisory rules, and I'll just run through a few of them. When a flag is so tattered that it no longer fits to serve as a symbol of the United States, it should be replaced in a dignified manner. A flag should never be used as a receptacle for receiving, holding, carrying, or delivering anything. The flag should never touch anything physically beneath it. The flag should never be used as wearing apparel, bedding, or drapery. The flag should always be permitted to fall freely. The flag should never be carried flat or horizontally. The flag should never be used for advertising purposes in any manner whatsoever. The flag should never be upside down except to signal distress. And when displayed vertically against a wall, the union should be to the observer's left. Now, this is the United States federal law. But the penalty for failure to comply with this is actually not enforced. And that's because it's likely unenforceable given past Supreme Court precedent. I wanted to talk a little bit about the case United States versus Eichmann. And that's the case, and some of you may have heard of it, but you might not know it by name, where the United States Supreme Court upheld that people are entitled to desecrate the flag, and that is actually protected under the First Amendment right to freedom of speech. So that is the Eichmann case. Okay, moving on from the flag code. A question that we get very frequently from our clients is, can the flag of the United States be restricted? And there is actually law on point with respect to that. And the quick answer is in very limited circumstances, okay? First, I want to talk about the federal law, which is the Freedom to Display the American Flag Act. And that actually applies to real estate management organizations, and that includes condominium associations and homeowner associations. And it restricts these entities, homeowner associations and condominiums, from restricting the display of the United States flag on owners' property. New Jersey also has a law which limits associations' rights to restrict the flag of our country. The site to that is NJSA 45:22A-48.1. But I'll tell you what it says. In short, it says that homeowners associations rules or bylaws prohibiting the display of United States flags, yellow ribbons, or signs in support of our US troops are not allowed. However, in limited circumstances, associations, community associations can restrict the display of these materials, the US flag, the yellow ribbons, and signs supporting our troops, if it threatens public safety, if it restricts the necessary maintenance of activities, or if it interferes with property rights of another. So in essence, homeowner and condominium associations cannot really adopt or enforce any rule that limits or prohibits the display of the United States flag, except in these limited circumstances, which I just discussed. And I'd like to give you an example of where I think a restriction would be reasonable. If the association, if there is a rickety flagpole, and it's, perhaps endangering, it might fall over and it might, harm somebody. Perhaps in that circumstance, not perhaps, in that circumstance, I think it would be arguably completely reasonable to ask that homeowner to correct the flagpole or take the flagpole down in that circumstance because it might harm someone. But with all of that said, associations should really tread lightly when it comes to restrictions on American flags, yellow ribbons, or signs supporting our US troops. Okay.
And I don't mean to interrupt you, but I think we got stuck on one of those slides. It probably should have been advanced already. If you could take a look at that.
Okay, so moving on to, it's fine, the next slide after that. Thank you, Arnold.
Welcome.
Okay, this is another hot topic. Are modified American flags to convey a political statement protected by law? And so some of you will recognize these flags. I just give you an example of a few. We have the Blue Lives Matter flag. We have what is known as the 3%er flag. And we have also what is known as the Betsy Ross flag. And I've actually seen this come up quite frequently over the past couple of months. Associations are getting calls because people might be offended by this. And boards want to know, can we restrict these flags? They look like the United States flag, but they're not the United States flag. So my position is as follows. These are not the flag of the United States of America. However, I think that these are political signs, and therefore we have to go through the tests that were discussed by Ellen, David, and Arnold earlier. New Jersey courts, as were referenced before, have ruled that associations' rules prohibiting a homeowner from placing a sign on his property in support of a political campaign or a political movement, I would argue, is in violation of free speech under the New Jersey Constitution. And if you want to restrict that, you really have to be limited in the restrictions in terms of the time, place, and manner of where you restrict it. Specifically, we cannot impose a blanket restriction on a unit owner's right to post a political sign on his own property. However, as I said before, we can still enact a reasonable time, place, and manner restriction. I don't think it would be reasonable to say you can place the political sign from midnight until 6 in the morning. I don't think that a court is ever going to find that to be reasonable. And so if this issue does come up in your association, you really need to confer with your association's attorney, especially if you're considering adopting a policy with respect to this. The Moderator case, in that court, the New Jersey, the Supreme Court noted that the New Jersey Constitution guarantees individuals a broad affirmative right to free speech under the Constitution. Okay, the court in that case further concluded that the constitutional right to free speech in the form of property signage may be curtailed so long as the restriction adopted by the association is reasonable, as I said before. Therefore, whether a restriction is unreasonable, that's really to be determined. And again, you should make that decision in consultation with your counsel and with advice from your manager. Okay, thank you. Moving on to the next slide. What about signs saying Black Lives Matter or All Lives Matter? This question has come up quite frequently. I even got a question about this "Don't Tread on Me" flag, and so I wanted to include it in this summary, and another flag, an opposing flag, saying "Tread on You." Now, while I understand that these flags may be offensive to one of the neighbors, given the current state of our nation, I don't think that this flag necessarily constitutes speech that we can restrict. So what does that mean? It means that, in my opinion, these are, in fact, perhaps political signs, and we still have to follow the rules set forth or the guidelines set forth in the Moderator case with respect to the restrictions on these types of signs or flags. And so you have to limit them as to the time, place, or manner. You can limit them as to the time, place, or manner. And again, that determination should be made in consultation with your counsel, depending on, where the flag is posted, how it's posted, and whether or not it's inhibiting anybody's safety or welfare. I understand, again, that these flags might be offensive to some. They might not be offensive to some. So others might put more flags up or signs up. However, that's not really the test, whether something is offensive to somebody. I want to talk about a few factors that can contribute to what could be an unreasonable restriction. What could be unreasonable is if the restriction is adopted unilaterally, if the restriction restricts too much speech, if there is no alternative, convenient, or feasible means of the speech being of the person expressing their right to freedom of speech, and was the speech limited in scope and affected only the private property at issue. Moving on to the next slide. All right. I often get the follow-up question, and so I wanted to address this with everybody. When I talk about signs and flags that might be offensive, however, they are political statements. And I am often asked, isn't this hate speech, Tana? Can't we restrict this because it's really hate speech and it's really offending others? Well, hate speech, in quotes, in the United States is not actually directly regulated due to our robust rights to free speech under the United States Constitution. I want to talk a little bit about a couple of Supreme Court cases on, what hate speech is and why we don't regulate it. First, in 1969, the court in Brandenburg versus Ohio actually protected a Ku Klux Klan member's speech and said that it's protected unless it creates an imminent danger. And so I think that you would be really hard pressed to find that some of these signs like Black Lives Matter or All Lives Matter are really creating an imminent danger. But if it is, again, that's something that you should discuss with your counsel if you believe that that's provoking an imminent danger or imminent lawlessness. This test has been modified a little from the Brandenburg from its inception. And it is now, if there is a clear and present danger, okay, from the display of these signs or from the speech that is being uttered, okay. Actually, most recently in 2017, in the case Mattel versus Tam, the Supreme Court upheld the issue was about the government prohibiting the registration of trademarks that were racially disparaging. And Justice Samuel Alito wrote in that case, speech that demeans on the basis of race, ethnicity, gender, religion, age, disability, or any other similar ground is hateful. But the proudest boast of our free speech jurisprudence is that we protect the freedom to express the thought that we hate. And when I read that, it doesn't exactly sound right to me, although this is our Constitution and this is what our free speech rights are. And in fact, it has been upheld time and again. So effectively, what the Supreme Court has unanimously reaffirmed in the Tam case is that there is no hate speech exception to the First Amendment protection right to freedom of speech. And it is a very strong and proud right in our country. And we really need to tread lightly when we're making rules and regulations in the association context.
All right, thank you, Tana. Appreciate that. So I know we've run a little bit over here in our time and we're going to be coming to our conclusion. But if you could move to the next slide, please. This is our last slide. So, in conclusion, what do associations do with all this information that we just went over in trying to make sure that their rules and regulations are enforceable? Review your rules, make sure they're reasonable. Make sure that you've reviewed those rules with legal counsel to determine if they will violate any constitutional or contract right of a member of your association. Does the rule restrict what is typically thought of as a constitutional right, such as freedom of speech? And lastly, is it reasonable based upon the time, place, and manner restriction permitted by case law that we've all reviewed in all of our presentations today? I want to thank Tana, Dave, and Ellen. I think it was very informative. And that will conclude our webinar. If we were unable to get to any of your questions, please feel free to reach out to any of us, but certainly keep a lookout for future webinars that our group will be presenting. I think everybody will be receiving a link to this webinar, and we will try to answer any unanswered questions that were presented in the chat group. So thank you everybody for attending. I hope you have a wonderful rest of the day. Take care.